There's a specter haunting New York City, and it's the coming eviction apocalypse that may be happening after August 31st of this year. It's the end of the moratorium on residential and commercial evictions. Hi everyone, this is Alan Rosinski of Metro Manhattan Office Space, and in today's real estate related episode, I'm going to be discussing the good, the bad, and the ugly of what might be coming at the end of this summer. There will be some dark times ahead for both residential and commercial landlords and tenants, but there will also be some hope as well, and some strategies that might mitigate some damage and help both landlords and tenants weather the coming storm. First, the ugly. How bad is this going to be? Unfortunately, really bad. Assuming that there will not be any extension of the moratorium on evictions, there will be a tsunami of eviction petitions hitting the Center Street courthouse as landlords scramble for their place in line to commence what will be a very lengthy legal process for getting rid of non-paying tenants. Service of petitions on tenants will likely be more difficult and take more time given the huge volume of filings. Courthouse calendars will be immensely overcrowded, even for the city, and no doubt extra security will be required to handle the angry and worried crowds of commercial and residential tenants. We have already seen, and likely will see again, protests by tenants in our streets, inflammatory speeches by the pro-tenant community and political leaders, as well as the press, casting landlords as the villains in this drama. When judgments and warrants finally issue from courts, the city marshals will be overwhelmed with the challenge of removing tenants and will likely need to call in the assistance of law enforcement officers to help keep the peace. Lawyers, either private or appointed to represent tenants, will of course use every available delay tactic to keep those tenants in place and use a deluge of filings to their benefit. On the other hand, lawyers for landlords will attempt to challenge the claims of hardship made by the tenants seeking to stay, delay, and not pay their rent. In short, it's going to be really a colossal mess. Now, the bad. Unfortunately, there will likely be numerous cases of violence. We will likely see fights in courtrooms, and arrests will almost certainly be made. It's not unlikely that landlords may have their offices invaded by tenants and tenant interest groups, and it's possible, because it's happened elsewhere, that lawyers representing landlords could be threatened and attacked. We will likely see a booming business for the private security industry, and also eventually for apartments and office renovation contractors who will be repairing the intentional damage caused by irate tenants, which means additional expenses for landlords. The incidents in landlord-tenant courts will spill over into the criminal courts, and various regulatory agencies of the city are going to be inundated with complaints against landlords, both real and fabricated. Now, the good. There's definitely hope. There are strategies and tactics which both tenants and landlords can use to clear up and diffuse this difficult situation. First, let's look at what's happening starting June 1st of this year. A program that might help up to 200,000 households is coming. New York has initiated the Emergency Rental Assistance Program, or ERAP, to provide economic relief to low and moderate income tenants at risk for housing instability, or in plain terms, homelessness brought on by an eviction. This program will base its measure of income on something called AMI, or Area Median Income, which differs by household size and county. If a household's income is currently 80% below the figure, they can qualify for ERAP. If after March 13th of 2020, a member of the household received unemployment benefits or experienced financial hardship due to COVID, either directly or indirectly, they may qualify for this program. If there are rental arrears on a primary residence after March 13th, 2020, they might also qualify. The tenant must demonstrate a risk of becoming homeless, or how the government prefers to call it, housing unstable. There's a priority among applicants, and for the details, I've left a link in the description below to this video. Up to 12 months of arrears may be paid, and up to 3 months of additional rent assistance might be offered if the tenant is spending 30% or more of their gross monthly income on rent payments. There is also up to 12 months of utility payment assistance available for tenants. The good news for landlords is that these payments for rent will be made directly to them. Landlords will need to provide copies of leases, documentation of arrears, and a W-9 tax form, as well as banking information for direct deposit of rent. That said, It's not all sugar and spice for landlords. The landlords will have to agree that the ERAP payment is in full satisfaction of the tenant's rent obligation for the time period covered. So it's very certain and specified that things like late fees aren't going to be collected. Further, the landlord can't increase the monthly rent above the amount due at the time of the application for 1 year after receipt of the ERAP payment. This is not applicable to landlords having 4 or fewer units and where the property owner's family intends to occupy one of the units as a primary residence. So one of the things that a landlord can do to help themselves as well as their tenants is make sure that the landlord communicates the existing benefits to their tenants and indicates that management stands ready to assist the tenants in their application for ERAP if they qualify for the program. Now, if you're a landlord with tenants who won't qualify for ERAP, there's still things that you can do to help yourself. You may wish to consider offering your tenants a payment to move out willingly, with the payment being given after they vacate. You can check with your lawyer to make sure that what you offer complies with current laws and regulations, especially if the units are rent-controlled or rent-stabilized. If you are in eviction court, as a landlord, you could try to settle with your tenant, giving them a reasonable amount of time to move out. My blog article on this topic, which you can read on my website, provides some more legal information to help you handle this correctly with your lawyer. A link is available in the description below. Now, Cuomo's legislation also puts a moratorium on foreclosures against landlords owning 10 or fewer dwellings until August 31st of this year. For commercial tenants, the moratorium has been extended for businesses with under 50 employees that can show hardship. And for commercial landlords, the moratorium on foreclosures has likewise been extended until August 31st. The previous moratorium expired in early May. These moratoria give landlords and tenants time to try and work things out. So if it isn't exactly going to be a win-win situation, it will at least be a lose-less situation. So, as a commercial landlord, what can you do now, as well as post-moratorium, to lighten your burden? First, consider taking all security funds available towards the tenant's rent arrears, which is something you are not obligated to do, but can, and then giving the tenant a schedule to replenish their security funds while staying current on the rent, or if that isn't possible, at least additional rent items like contribution to taxes, common area maintenance fees, and if your lease provides for it, insurance costs. You can find some more detailed notes for landlords in my blog article. Feel free to take a look. There's a lot of valuable information. Now, for commercial tenants, one of the greatest concerns involves any personal guarantee that might exist and the actual wording of the good guy guarantee clause stipulated in your lease. Your good guy clause may only personally obligate you to guarantee timely payment of rent for actual occupancy periods. However, if you violated that due to an inability to pay, then a properly drafted good guy clause from the landlord's point of view will make you personally responsible for rent due for the entire lease term. This assumes that there is something called an acceleration clause upon tenant default, which there often is. As a result, you may end up with a massive judgment against you personally, so please be aware of these possibilities. Now, landlords and tenants are not always and not necessarily adversaries. It would benefit both parties to sit down and try to work out temporary or permanent accommodations and to avoid the likely hell that will be the eviction proceedings starting this fall. New York will survive, and New Yorkers, both landlords and tenants, are tough enough and smart enough to work things out in these trying times. Tenants who are smart will engage the services of an experienced tenant broker to help them navigate the waters of this flood and wind up successfully on dry land, safe and sound. My firm is here to help when you need it. If you have stories or concerns of your own, whether it's for yourself or a company that has been employing you, please feel free to share your questions or observations in the comments below, and I will do my best to help. If you found this content interesting or helpful, I'd be happy if you subscribe to my YouTube channel. You can always find me on Twitter. My Twitter handle is @MetroManhattan. Until the next time.